Studio. It's our pleasure to welcome now Professor Christopher Green, the Assistant Director of the Chase Center for Civics, Culture, and Society at The Ohio State University. Professor, always good to see you, sir. I've been watching all this tariff stuff, and, of course, the courts are weighing in so heavily at all levels, it seems. I thought of you and asked Alex to call you up and get you on, so we appreciate that, to try to enlighten us and shed some light on all these complexities, because there's laws and there's precedent and there's policies and standards and rules and conditions. It hurts my head. Help us out here. What the heck's going on? What's up with the federal court that ruled last week, right? In what was the ruling? 7-4? I can't remember the exact
7-4. So this is kind of an unusual court. This is the Court of Appeals for the Federal Circuit, and they handle kind of when you sue the federal government for money. So the Court of Claims, or if you have things in the this thing called the Court of International Trade, the appeals go there. They mostly handle patent stuff, so they tend to have some really STEMmy people, but then they also have this stuff of huge significance for the way the federal government operates. So a lot of what they were fussing over was going back to Nixon and Congress being upset with what Nixon was doing in 1971 with the. They keep talking about the NEA, but it's not the National Endowment for the Arts. It's the National Emergencies Act. And it's kind of wild just going back to, they just had all these, Nixon and lots of presidents said, well, I got to do this. It's an emergency. And he had a whole bunch of emergencies, so they went through. They actually had a 1.5-year study to see just how many emergencies had been declared. So anyway, they passed a new statute. So a lot of what they're fussing over in the decision about the tariffs is just exactly what the president can do under these various emergency statutes.
Right.
So there's a statute saying he can restrict trade. Does that mean just he can completely cut off trade, or does that mean he can impose a tariff? And the president is enthusiastic for tariffs, and there's a bunch of questions about like what exactly did they do in the 70s. Courts had stepped in and said some things about what Nixon had done, and then there was a statute that was passed, and it sort of embodied some of what was in that earlier decision, and maybe not all of it. But then the open-endedness, I think, of what the president was doing, the fact that it really seemed to give carte blanche to restrict trade in whatever extent he wanted. That was clearly disturbing the court last week. It is clearly going to disturb a bunch of people on the U.S. Supreme Court. So, there's a provision saying it has to be renewed every year, these particular emergencies.
Right.
But he, there was nothing about necessarily the reasons for these tariffs that wouldn't necessarily apply in a year. They might not. Clearly we've had various kinds of trade deficits. We consume more from certain countries than we sell to them. But there's a question: is the president required to show some spike in it, something special about what happened Tuesday or something that justifies being all worried about Canada suddenly? Generally, so if we went hardcore and said the president can only really deal with emergencies, so stuff that's been around forever has to be done by Congress, there'd be a tougher question about that. But here we're just interpreting a statute that uses the term emergency, and it has to be unusual or exceptional. Is this the normal kind of trade deficit we have? Well, sort of. I mean, things are always changing.
It seems like what complicates this, though, Professor, is define emergency. I mean, that seems like that's extremely subjective, and I guess we're going to rely on the courts now, the Supreme Court, to say, yeah, a trade deficit is or is not an emergency.
Yeah, and they could. I mean, one way they can do it. I mean, basically, they could say the president is required to tell some kind of story about a change in why this was different from what it was a year ago.
Okay.
And they could say, once the president tells a story like that, they're not going to second guess whether that story is true. Obviously, in international relations, you have a lot of stuff that's secret, stuff that's suddenly happening. The military implications a lot of the trade. We're obviously not going to want to be, going into court and saying, we're really worried about our ability to produce X, Y, and Z because there's fancy stuff in our, next generation, stealth technology or something.
Right.
So there is a need for secrecy, and there are stuff that's changing. So generally speaking, if you wanted to enforce it, you would say, require the president to tell a story about something that has changed, that has emerged. That's different different than how it was when the Congress passed the statute. Because you say, well, if it's just been around, just go to Congress for it. But generally speaking, it's going to be something that has changed. Whether it's a critical thing, the magnitude of things, I think there's no question the courts want to defer to the president about the size of those things. So we hear, like, oh my goodness, if we don't do this, New York is going to get nuked. And then always the question is, well, what about Newark? So, to the extent to which you've got to save X number of people, how many zeros have to be on this number? The courts aren't going to want to second guess that. But just whether or not somebody has told a story of the right kind, that is the kind of thing they do with respect to the EPA, with respect to lots of agencies. The president is not subject to it generally, but they could have a kind of a Administrative Procedure Act-like requirement about telling a story.
Okay, so the act that I hear referred to the most, Professor, is the IEEPA. They actually say IEPA in common language. The the International Emergency Economic Powers Act. Yeah, and I think that's pretty old, and so that's what at least the administration contends they're relying on. And then I've also seen the plaintiffs say, hey, well, this is a tax. The president doesn't have the power to tax. And the administration says, well, this is temporary. Taxes are permanent, right? And that which is also kind of part of what would authorize and satisfy the conditions for the president to impose these tariffs. Talk about that. Yeah,
so it's a lot of the same kind of stuff we had, 13 years ago with all the Affordable Care Act stuff, where they have a requirement and they say, well, it's really a tax. And there's a bunch of old cases where, like, Congress would tax illegal activity, and it's like, how can you tax marijuana and send somebody to jail for not paying the marijuana tax?
Gambling is a huge example of that.
And they say, well, we're allowed to tax stuff that's illegal. It's, you can tax something for the purpose of restricting it entirely, and you can, if you have enough flexibility that you see in the statute, you can impose something that makes you pay some money when you do something, which you think that's what a tax is. And the phrase temporary tax isn't a contradiction in terms. So the mere fact that it's not permanent doesn't necessarily mean that. But the president can impose all kinds of conditions on people, and he can negotiate rates. That's part of why we have a president, is to be able to do these kinds of delicate negotiations without having to do it openly and at the pace that Congress can go. So it looks a lot like a tax, and it functionally is, but the question is still, is that in the exclusive domain of Congress under Article 1, Section 8, Clause 1? There are big questions about whether a bunch of stuff that Congress is doing has to be exclusive, or whether that's a power that's shared with the president, whether the president can act in the absence of congressional action banning it, whether the Congress can go, whether the president can go ahead and do that. There's a bunch of stuff in Article 1, Section 8 that the president can act if there's an emergency. Repelling sudden attacks is the kind of thing that coexists with the war power.
Yeah.
And this could be the same kind of analysis. But you could see it either way. I would say it's, 7-4. There's clearly some pretty meaty arguments on either side. Statutory construction, Chief Justice Roberts has been willing to kind of twist statutes with the taxing power from 2012. Seeing a mandate to do something as a tax, especially now it's a tax with no actual tax to it.
Yeah,
it's still seen as a tax. I would think if he feels like it's a good policy, just saying like, hey, Congress, if you want to authorize this kind of open-ended emergency stuff, you got to do it more clearly. So
we're up against a break, but if you can hang around, we can keep talking through a short segment. If you can hang around, you good?
Sure, yeah. I'll be back in a minute.
All right, we got Christopher Green. Stay with us. We're talking to Christopher Green, Assistant Director, Chase Center for Civics, Culture, and Society at The Ohio State University, just discussing this court action regarding the president's imposition of tariffs. And before we move on, Professor, it's temporary, right? It goes into effect, but they got like a month or so to sometime in the middle of October to kind of make the case. Isn't that what happened?
Yeah, they put it on. I think they posed a stay, and they're giving the president the opportunity to petition the Supreme Court and ask for relief, or it seems very clear they're going to send up a cert petition, and if the Supreme Court wants to kind of change what the interim rules are going to be while they decide that, they can do that, but. The intermediate court clearly trying not to be as jarring as it would otherwise be if we suddenly don't know who we're supposed to be following in terms of the tariff rates. And also the delay does give the president, if he wants to go back to Congress and get a more explicit negotiating authority, Congress can of course pass things in the interim.
Yeah. Well, I just thought that was interesting that I guess they have some time to kind of sort it out and make their case. Peter Navarro, of course, who advises the president, he penned a very interesting piece where he makes the case with the opinion that the president and the administration will prevail in this particular situation, and actually cites something I guess I hadn't thought about, which is, well, if you have this major question doctrine, right? If the president can ban imports altogether under his authority and under this doctrine, that imposing tariffs is actually a lesser action in their view. And certainly if the president can ban imports, they also ought to be able to impose tariffs. Your thoughts?
Yeah, that's one of the arguments from the dissent that I think has some considerable force. That so the idea is we've got this constitutional doctrine, or it's kind of the shadow of the Constitution, that we don't want to give the president too much power unless the statute really goes ahead and is explicit. And the statute that we're talking about is explicit that the president can completely cut off imports. And it would be a little weird to say that because we're worried about giving the president authority to do big dramatic things, we don't want to interpret that greater power to include the power to make exceptions. So to allow stuff in only if you pay a certain amount of money. So the general vibe of giving the president flexibility and interpreting the delegation reasonably so that it doesn't make the president have to do big dramatic things is a little at odds with the particular interpretation that the majority is going with. On the other hand, if you think, no, we're just going to require Congress to speak explicitly if you're going to have this level of executive discretion, just make them speak explicitly. And it's only this one particular emergency statute is only for, cutting off stuff coming into the United States. I mean, it is a little bit weird to talk about the emergency, just like the international emergencies about stuff coming in. Usually, the big emergencies that we're talking about with national security about stuff going out. So if we've got secret information technology, well, there's all these rules about exports.
So it's chips, really, for example.
But the lack of a perfect fit with the purpose of the statute. The statute says what it says, and if we're going to interpret it to allow the president to make the key calls, and like the really basic calls about what's dangerous, how many people are impacted. Of course, don't want to hold hearings about that kind of stuff. So back in the day, Justice Douglas, he issued injunctions against bombing of Cambodia. And, the Defense Department was like, what? They kept having to go to the full Supreme Court and say, this is crazy. So they don't want to have that kind of second guessing of just the magnitude of risks.
Sure.
I think a lot of them are probably a lot more free trade people than the president is. So, the extent to which they want to kind of allow these really big shocks to the international economy. The argument that this is a pretty big question, there's no question it's big. It's just a question of really has Congress spoken sufficiently clearly? And is there an alternative interpretation you can give that'll make more sense? The alternative interpretation, it makes it all or nothing in a way that is a little, maybe not the best. You don't want to, require the president to go full bore on restrictions.
We got to go, but always appreciate your insights and your analysis. We'll talk to you soon. Christopher Green from the Ohio State University. Appreciate it. Coming right back, folks.